Hello, my name is Azmi Sharom. I'm a lecturer in human rights at the Faculty of Law, University of Malaya. And today, our class is going to be about human rights and business. There's been much debate about the relationship between business and human rights, and this class will look over these arguments. It will also cover why business should protect people's rights and the various ways that organizations have tried to ensure business complies with human rights standards. We'll finish up by looking at some case studies from the region on this relationship. Though all business activities have some type of impact on human rights, there is still debate about whether business should be forced to comply with human rights standards. Firstly, let's look at why this relationship is open to debate. Looking at the relationship, business is both good and bad for human rights. On the positive side, business can ensure people get their rights. People need business to create wealth. Business provides important services like food, housing, travel, and so on. However, some businesses can be bad for rights. Business can exploit people, they can pollute the environment, damage democracy, create financial instability, and increase discrimination. Obviously, everyone wants business to only produce positive results. But how can this be enforced? The question here is how to make sure business complies with human rights. Now, some points of debate are, firstly, does business have a duty to protect human rights? That is to say, is it a duty bearer? Or is it the role of governments to protect human rights? After all, they're the ones who signed and ratified the treaty. Business should comply with national laws only. It is not up to them to comply with international law or human rights law. But what if the national laws do not comply with human rights? The businesses are not breaking any law, but at the same time, they're not protecting human rights. Let's look in more detail at these issues, including defining business and understanding what a human rights duty bearer is.
Business means any kind of profit-making organization, from those which employ one person to others which employ thousands. Of concern to human rights are two kinds of businesses. Firstly, corporations which are legal entities that have rights and duties in some way similar to individuals. Because they are corporations, they have limited liability, and this legal status can be misused to avoid respecting rights. Secondly, transnational corporations, or TNCs, operate in more than one country. They may employ tens of thousands of people, and a big TNC may have an economy similar to a medium-sized country. Because of their size, or that they work across borders, may enable them to avoid some human rights obligations. A central debate is how business should comply with human rights. The question is, are they human rights duty bearers? Or should they just obey the law in the country, regardless if this complies with human rights? This means, do they have a duty to promote and protect people's rights? Some say that business are not bound legally to human rights treaties, as only states can do this, so they do not have legal obligations towards human rights. However, another viewpoint is that human rights are universal, so they should be protected by everyone, and businesses cannot escape this responsibility. So business must abide by the human rights laws. They must comply with human rights. The challenge is when the state does not recognize these rights, or if the state has laws which go against human rights. Which laws should a business comply with? The international standards or the national law? What if the business works in an area where there are no national laws, like in the middle of an ocean? Who can force them to comply with human rights? Another way to describe the duty of business is through the concept of horizontal effects. A horizontal effect is where a private organization, like a business, should protect human rights because they must comply with the national law, which is the result of a vertical effect. Part of a state's duty is to ensure everyone in its jurisdiction complies with human rights. It can do this through its vertical effects, which is the power, a state has to enforce third parties to comply with the law. When the third party complies, the effects of the law become horizontal. It is between people and companies. Let's get an expert view on business compliance with human rights.
Businesses do have to comply with human rights, and this is nothing new. This was a big point of debate throughout the 2000s, and then you had the UN Guiding Principles on Business and Human Rights, and they clearly state that business enterprises do have a legal obligation to respect human rights, and they outline all these kind of measurements and actions that businesses must take. But the entire debate is kind of misguided because this is clearly outlined in UDHR Article 30, which says that no one can infringe upon the human rights of others. And this, of course, carries over to businesses.
So, what are the relevant human rights for business? We can simplify this into three areas. Firstly, there are labor rights. Labor rights are part of economic, social, and cultural rights found in the ICE-SCR. They cover a lot of areas, including fair wage, working hours, non-discrimination in the workplace safety, right to holidays, and so on. Mostly, these standards are developed by the International Labour Organization, the ILO, which is the international body focusing on labor rights. But these rights, these labor rights, do relate to human rights. What if a business decides to pay women less than men, or not employ someone because of their religious belief? These are clearly human rights violations. And also, in all ASEAN countries, they would be against the national laws about discrimination. A second important area is the impact of the business on people in terms of the environment and pollution and consumer rights. As the environment class details, there are many cases in Southeast Asia of businesses severely polluting the environment, which negatively impacts surrounding communities. A third important area relates to governance and democracy. Some businesses are so powerful that they can influence governments and threaten democracy at the local level and even at the national level. A business can engage in corruption so they can buy land cheaply or avoid following laws. These can threaten the democracy of a country. So, what has been done with all these threats? I mean, what were the responses? Firstly, there are a number of voluntary systems where businesses promise to abide by rules and comply to standards and behavior. This self-regulation, known as corporate social responsibility, or CSR, is where a business accepts its responsibility to the community. CSR can involve running charities or engaging in community welfare activities or business-led compliance organizations. Some of these are very successful activities, while others can mean very little. Voluntary pledges from business and CSR that focuses on what businesses do with their profits rather than how business enterprises make their profits have a couple of obvious shortcomings. Firstly, voluntary initiatives make human rights optional and not an obligation. Secondly, the voluntary approach gives the option of revoking its commitment at any time. And voluntary approaches often lack substance. Monitoring, even by an external party, can be manipulated. A business may make public pledges and employ community outreach strategies that are more about brand promotion than it is about human rights. That's not to say that voluntary initiatives are not useful. They can lend to business accountability. One of the more well-known examples is the UN Global Compact, which is a global system with thousands of organizations participating. Let's take a look and see how this works.
Corporate Social Responsibility, or CSR, is a business-led initiative which believes that business has to be responsible for its actions in relationship to employees and their families, to the local community, and to the environment. Because CSR is voluntary, there's a lot of variety in how a business creates CSR. It can be how business complies with laws and regulations, or it can involve running charities or community welfare activities, or it can be charitable donations. CSR attracts criticism because it seems more concerned with marketing or with social contributions. Critics also note that the focus should be on whether the actions of a business comply with human rights law rather than the charity it publicizes. Nevertheless, CSR is often the only way a business engages with human rights. One example of CSR is the UN Global Compact, set up in 1999 by the then Secretary General Kofi Annan. Partially, this was because more stricter measures to force business to comply in the 1980s and 90s did not work. So, a business-initiated, voluntary, and self-regulation measure was put in place. The Global Compact works by having companies volunteer to be part of the compact, and by doing this, they commit to principles in the areas of human rights, labor, environment, and anti-corruption. The companies self-report on their compliance, and they can appear on the Global Compact homepage, where they highlight their CSR policies and practices. There are around 8,000 businesses who have taken part. Briefly, the 10 principles of the UN Global Compact: support and respect human rights, not violating human rights, uphold the freedom of association and collective bargaining, elimination of forced and compulsory labor, ending child labor, elimination and discrimination in employment, be careful about environment challenges, promote greater environmental responsibility, develop environmentally friendly technologies, and work against corruption. In some ways, the Global Compact is a success. There are 8,000 companies who are part of it, and they widely advertise their efforts towards CSR, labor rights, and environmental responsibility. However, there are criticisms. There are no mechanisms to monitor the business or to criticize it in any way. Because it is voluntary, only businesses who comply with the principles will join it. Businesses involved in human rights violations will simply not join the compact. Because it's self-reporting, it is possible for businesses to self-report compliance with the principles while hiding violations. As an example, tech industries like mobile phone makers can be compliant, but only if they ignore the work violations in the factories where they outsource their manufacturing to. It could be argued that many of these criticisms attack the Global Compact for being something which it is not. It is not a monitoring and enforcement mechanism, nor a way to punish companies. Rather, it is an initiative to encourage companies to develop their CSR profile. The Global Compact is the largest CSR initiative, and although there are no monitoring mechanisms, thousands of businesses have pledged to uphold human rights.
All of Southeast Asia countries have ratified UN Convention Against Corruption, and they all have companies involved in the UN Global Compact. In Southeast Asia, corporations can be held accountable for their actions, but this is limited in Vietnam and Singapore. The corruption ranking by Transparency International ranks Singapore as the least corrupt country, and Myanmar, Cambodia, and Laos as the 3 most corrupt.
For many critics of the Global Compact, they say that the problem is these standards are not legally enforced. Since the 1970s, international organizations like the ILO, the OECD, and the UN have attempted to use legal frameworks to demand business accountability. The challenge is that most companies, indeed most of the countries where they come from, do not want to see such a legal standard introduced. There was also no consensus about which human rights should be enforced or who should do the enforcing. At the UN, there have been a couple of initiatives. Firstly, there was the Global Compact, which we discussed just now. But then in 2003, there was the UN norms, which did say that businesses had human rights obligations. It was quite strong on the protection of rights. Unfortunately, it was not widely supported. So, in 2011, the UN established the Guiding Principles on Business and Human Rights, which introduced the protect, respect, and remedy framework. The guiding principles are not as strong as the norms, but they do say that states have primary responsibility and that business should obey domestic law. Business must act with due diligence. They should have human rights policies, but they are not primary duty bearers. Let's look at more detail at these principles.
The UN Guiding Principles appear in 2011. They're also known as the Protect, Respect, and Remedy Framework, or sometimes called the Ruggie Principles, after their author, John Ruggie, who was a special representative for business and human rights at the United Nations. There are 31 principles in the Guiding Principles, laying out the roles and responsibilities of states and businesses. They give states primary responsibility to enforce human rights by stating that the obligation and the primary responsibility to promote and protect human rights and fundamental freedoms lie with the state. The role of businesses are to comply with all applicable laws and to respect human rights. These separate duties form the basis of the principles, which are to protect, respect, and remedy. Let's look at the three pillars of the principles. The first pillar is to protect, which is primarily the obligations of the state. The state has a duty to protect the human rights of people within its territory against human rights abuses by third parties, including businesses. Activities related to this may include putting policy and regulations in place, ensuring they are enforced, increasing corporate awareness of human rights, having extra oversight for situations where violations may occur more frequently, for example, in conflict zones or in extraterritorial business situations. This is where a business is working in a foreign country. The second pillar is respect, which is mainly for business. Businesses have a responsibility to avoid violating human rights, which can be done in a few ways: by ensuring due diligence, or ensuring laws are respected, environmental impacts are monitored, and the workplace is safe. By having a human rights policy that outlines how human rights are respected. By being aware if a state violates rights and not become complicit in this, or profit from state violations. As an example, investors could be attracted to Southeast Asia because of low labor costs or cheap land. However, these incentives may be the result of governments violating rights, such as exploitation of labor or confiscating land. The third pillar is remedy. Both states and businesses have a responsibility to ensure that someone whose right is violated have access to a remedy. This could be compensation, a tribunal, or a court. The guiding principles are a current attempt to ensure business complies with human rights. They are an improvement because they declare that businesses have a responsibility to respect human rights regardless of where they operate. But there is no mechanism ensuring companies will do this, nor any punishment if they don't. This is the challenge of making business comply with laws. Let's hear expert views on why businesses can ignore human rights.
Businesses can find ways to avoid some of their legal obligations under international human rights law when it comes to things like pollution, workers' rights, all of these sort of areas. Businesses may knowingly undermine rights and knowingly exploit the situation. And they can get away with it simply because governments either don't have the legal framework in place or aren't enforcing the regulations that ought to be there. And the entire situation boils down to businesses taking advantage of the situation. And one thing that is worth noting is that in the long run, this puts them in a susceptible position in terms of sustainability.
So what do you do when there have been violations by business? Now, there's a range of things that people can do. One successful method is by consumer activism, such as a boycott. Famous ones have included the Nestle boycott in the 1970s because of how the company sold baby formula in Africa. More recent boycotts include Nike shoes. Another response is legal action where people have taken business to court because it breaks environmental regulations or it mistreats workers. Cases include the closing of copper mines in Myanmar, the fining of pollution causing factories in Thailand, and limiting deforestation in the Philippines. A new method has been the use of extraterritorial obligations, which is where companies are brought to court because of violations that they have done in a third country. An example is a Thai company being brought to court in Thailand because of the activities in neighboring Myanmar or Cambodia. This new development is of particular importance to Southeast Asia because of the Bangkok Declaration on Extraterritorial Human Rights Obligations. For instance, the Thai National Human Rights Commission is currently investigating 4 extraterritorial cases: sugar plantations in Cambodia, a dam in Myanmar, a mine in Laos, and another dam also in Laos. While there are many questions and challenges that stand in the way of reliable extraterritorial accountability, transnational advocacy has led to more attention on extra-legal questions. Let's look at a couple of case studies on how civil society has successfully responded to business which violate human rights.
One of the first boycotts was over 300 years ago when people in Europe protested slavery by not using sugar, which came from plantations using slave labor. More recent boycotts include Nestlé products over their marketing of milk formula to replace breast milk for children, which many saw as bad for the health of newborn children. Others include boycotting Nike over poor labor standards and Shell Oil for pollution caused by oil drilling in Nigeria. States can use trade embargoes to force a company or a whole industry to change its practices. Recently, the European Union has criticized the prevalence of human trafficking in the Thai fishing industry, and some supermarkets threatened to stop buying Thai seafood. As a result, there has been much change in the Thai seafood industries around worker standards and more ecological fishing practices. Though, as the migrant worker class shows, trafficking and migrant worker violations have not disappeared yet. A final example is the use of extraterritorial obligations, where a company may face justice outside the country where the violation occurs. This has been used many times in Southeast Asia. One example is of Thai Sugar Company with cane sugar plantations in Cambodia. There were many complaints that thousands of villagers were forcibly evicted. The villagers tried to make a complaint to the court in Cambodia, but they were not heard. So, they filed a complaint in England against a British company which had contracted to buy the sugar. Another example is villagers complain against the Sayaburi hydropower project in Laos. They claim the dam violates the right to a clean environment, including the rights of people to access their natural resources, to conserve the environment, and to participate in decisions that might affect the environment. The dam is in Laos but financed by Thailand, and the villagers are in Thailand. Even though the dam is outside Thai jurisdiction, the villagers complain was heard in Thailand because its impact does cross the border. While it is still unknown if these actions using extraterritorial obligations will be successful, this is another way to ensure business complies with human rights.
So, in this session, we spoke about evolving norms in the field of business and human rights. While there are many initiatives and frameworks to guide and influence both business enterprises and governments, there's a lot of work to be done still in terms of strengthening relevant norms and mechanisms, particularly with regards to enforcement.